You're listening to Cover Your Assets, a podcast that discusses the timely and significant legal issues faced by employers. Kathleen Jennings is an attorney who has over 30 years of experience in advising employers as to their legal responsibilities and has written extensively about employment law in her popular Cover Your Assets blog. If your business has employees, you cannot afford not to have your assets covered.
Hello, everyone. Welcome to Cover Your Assets, the labor and employment law podcast. And since you can't see us, you don't know that we're both wearing tie-dye today. So I'm not sure that has anything to do with today's topic, tie-dye, but that's what we're wearing. So how are you today, resident expert, a.k.a. attorney, Kathleen Jennings?
Doing great, Tom. How are you doing this wonderful holiday weekend?
Well, we're here in Western New York, so we're looking at June very soon, so it should stop snowing any minute. Yes, no, it's a beautiful day here in Western New York. How's things down in the lovely state of Georgia?
Things down here are hot and humid, which is about par for the course for summer, but summer starts early.
So before we get into our topic today, which will be employer monitoring of employee use of technology, and we're going to have to come up with a more succinct title. Succinct, by the way, is the word of the day.
We could call it I Spy with My Little Eye.
Ooh, that's, no. Anyhow, so we I went through and looked at the statistics of the podcast. I found something very interesting. Now you're in Georgia, which I believe is in the United States of America, and there is another country.
It is the state of Georgia, yes, not the country of Georgia.
Well, isn't there a country of Georgia?
There is a country of Georgia in Eastern Europe.
It's in Eastern Europe. Well, we do have listeners in Eastern Europe in a little country called Russia.
Russia.
Yes, we've had.
That's interesting.
3 listens in Russia.
Wow. So that means we're international.
We are indeed international. We are broadcasting to the lovely country of Russia. So I just want to say to our 3 listeners out there, if one of them is Vladimir Putin, please just stop. Just stop. So, topic today, and we'll go through this. This is I don't know. We were talking before we came on air about some people that have done some kind of crazy things in terms of using technology at work for nefarious purposes. So we'll start out with, I think we actually touched on this one before, but New York State recently passed legislation, and usually when one state does it, other states will either have some kind of laws that are similar, or, it's the domino theory, I suppose, in employment law, where the employer has to notify the employee what is being monitored in terms of their activity, whether that be phone conversations, recording phone conversations, which I think would be relevant, let's say in, customer service industry, if you're making a lot of calls and talking to people, and that's to protect the company in case somebody makes a claim that the representative said something that they didn't, and so on and so forth. Email, which is be a big thing. But then, the other thing I think sometimes people don't necessarily think about is internet usage. So if you are given a device and you bring it home, your employer will likely have the means to monitor whatever activity is on that device. And even if they can't monitor at the time, they're going to be able to figure out what's been done on the computer once you turn it in and all that kind of stuff. So, and I think it goes, we read one article that said it takes I hate to use this term because it sounds very degrading, but it takes a special kind of stupid to not realize that your stuff is getting monitored. And I think you discussed a case where somebody was doing an email dump before they left an employer, and it became an issue where it was a breach of confidentiality, or what was that?
It was a breach of a non-compete covenant in their employment agreement. So that's where that would come up. And then you have just the people that are using their company's resources for non-work purposes. Are they shopping? Are they looking at porn? Are they participating in March Madness pool?
Yeah.
Or maybe even fantasy football?
Well, I'm going to make the confession right now if my employer is listening, which they probably aren't now. But yes, I've done some fantasy football transacting on
I figured you
computer.
had.
We actually, it's
That's why I raised it.
It's funny you mentioned March Madness, because I remember when I was working at a not-for-profit, and actually it wasn't March Madness. I know March Madness, we all got in trouble. We got sent one of those emails like, please don't watch March Madness games on your computer because it's dragging the network down. But we had a situation where one of our former students was on the Steve Wilkos show, and Wilkos was the guy that was he was Jerry Springer's, bouncer. And so this was that kind of thing. It was one of those, kind of crazy things. So this student was on this Steve Wilkos show, and we all were streaming it and shut down the computer network. So it was the employer, our employer, my employer at the time, who shall remain unnamed, was not too happy with that. The video itself, though, was hilarious. So I'm not gonna.
And I'll confess that kind of thing happens at my office up in Atlanta. If one of the partners is doing a webinar or some kind of video call, sometimes they have to send around an email to the staff to tell them to stop streaming or whatever they are doing that slows the network down. So it happens everywhere.
And in that case, really, that becomes a matter of really a disciplinary issue, or just, employers just telling people to stop it. Like you said, it's not a big deal. It's probably not going to get you terminated unless it becomes really abusive. So, March Madness, it only happens in March. There's other times where maybe there's some sporting events that could potentially bog down the network, but you may not see that as much anymore because people can bring their personal cell phones to work and stream that stuff very easily now. So let's get into the stuff that maybe employers, because this is a podcast for employers, should be wary of. Let's start with, how would you craft a policy that would protect you from situations where, we mentioned porn at the beginning. Okay. So if, generally speaking,
you mentioned porn. I didn't mention porn.
I believe if we go back in the recording, you were the first person that actually used the word porn today.
Okay. We'll check.
So anyhow, now you made me lose my train of thought. You see, this is that brother sister thing, is that you just knocked me off what I was thinking. But anyhow, my train of thought was this. Okay, so let's say employees are just typically using their computers for personal stuff, fantasy football, streaming YouTube videos, watching television shows, all that kind of stuff. But then it does shift into that word that you mentioned first in this podcast, porn, which could be a huge problem. If there's, is it correct that if there's not a decent policy in place, or maybe there is a policy in place in terms of use of employer resources that could get an employee fired, do you have to worry about crafting the policy, or do you have to be consistent on enforcement? So, example, I'm watching March Madness, shutting down the computer network, but somebody else is watching porn, and the watcher of porn turns around and says, well, everybody watches stuff on their personal computer, so why am I being penalized?
Well, I think when you say, is it important to craft the policy or consistently enforce the policy, both are important. I think it's important first to have a written policy that puts all of your employees on notice as to what kind of monitoring you are doing of their activities. And some state laws, as you pointed out, New York, require that. So the first step would be, as in many cases, know your state law. What does it require? Is there specific magic language that they want you to have in your policy? But it's important to have the written policy and be transparent about what you're doing, because that way if you find employees that are abusing company resources for and doing activities other than work on their computers, and you want to discipline them for it, you have this policy right here where you can sit them down and say, look, we're monitoring you. You know that we can check on what you're doing. We did check, and here's what we found. And so that's, if you're watching porn while you're supposed to be working, that's not productive. And if the employee is streaming the porn on a company computer or in a company cubicle or a company office and somebody else sees it, now you're running into a potential sexual harassment issue as well. So there's a lot of layers to this problem. And then secondly, of course, as you pointed out, as with any employment policy, it's important to consistently enforce it. So the person who is looking at porn while they're at work is not being productive. And so is the person who is watching the March Madness basketball game while at work. So if you want to impress upon employees how important it is to be working rather than goofing off, then both of those folks need to be disciplined or counseled, or however your progressive discipline policy would handle those situations.
And I think that, we're talking about at work. Now, the term at work, traditionally always meant you're going to the office. But let's face it, the workplace has evolved, that a lot of people have started working at home. And in many cases, in order to accommodate an employee that was working at home, they were given a laptop or something to do their work at home. So I guess that leads to the question. I think we all know the answer, but we'll discuss it further. If you're sitting at home and you're watching porn on the employer issued laptop during work hours, we know that is obviously a no-no. But here's the real question. So if I took the employer issued laptop and I was watching porn off hours, would that be something that would be subject to discipline if it's not in the policy or not? Because I think that kind of falls into a gray area, doesn't it?
I think that's where you sort of come into the special kind of stupid, because if it's an employer-owned electronic device, whether it's a phone, whether it's a laptop, whether it's a tablet, you need to be aware that, and if there's a policy that says the employer can monitor all your activities on that particular electronic device, it really shouldn't matter when you're viewing the porn on that device, because if the employer looks on it and sees that you're viewing porn, it just doesn't look good for the employee. Yeah, maybe they're doing it on their off hours, but it shows a certain lack of judgment that even though they know that their activities are being monitored on this device, they are still using an employer-owned device to do something that is inappropriate. So it's just not a good look for the employee. That's why you get your own phone, your own laptop, do that stuff on your own time. That's your business. But once you start doing these activities on employer-owned electronic devices, it's not your business anymore. And it could affect an employee's career.
Is there a case where I heard of a case and that of a gentleman that lived near me, and he was arrested for being in possession of child porn. And when they did an investigation into the porn and everything, like, they went to his employer and confiscated the work computers. And is there any potential liability in terms of an employer if a device is used for illegal activities and maybe they didn't take proper precautions to either monitor or maybe prevent access to certain types of things?
It's possible. There's always possible liability for a number of things. If the employer undertakes the duty to monitor its employees, then it may be a breach of that duty if it lets illegal or unlawful activities go by without doing anything about it, without perhaps reporting it to the authorities. But if the employer doesn't know about those activities and has not undertaken a duty to actively monitor everything that happens all the time, there may not be liability there. So it really depends. That's the answer to most legal questions that we lawyers like to give. It depends.
Well, and we recently, at the time of this recording, this shifts to a little bit more serious, but topic. But we've had some shootings, and there's definitely been an increase in violence with guns and other types of things, and sometimes it's workplace shootings, school shootings, any of that kind of stuff. So I'm wondering, because you mentioned if the employer discovers something on a device that is illicit, like, watching porn, but you could take that one step further. If you had an employee who was mentally unstable, that was maybe going through a difficult time and having a hard time at work, they could, we'll just use this for an example. Maybe they were searching online, how to shoot up your workplace. Stranger things have happened, or even just shopping for weapons to bring to work. So in that respect, should employers now maybe be more cognizant and more vigilant when it comes to monitoring communication? Because I would imagine that it would be difficult to monitor each and everything an employee's doing, but maybe a spot audit of the emails just to look for some things to make sure that there's no red flags. Or again, if you have an employee who is starting to have a difficult time in the workplace, maybe at that point saying, hey, we just need to take a look and see what they're doing on their device.
I think the situation could arise where if an employee reports that another employee is exhibiting concerning behavior, maybe they're afraid that this employee is going to do something, maybe they're afraid that there have been threats or mental health issues. At that point, it may be appropriate for the employer to then monitor the email account of the employee who has been reported on, just to see if there's anything in there that could cause the employer to escalate this to law enforcement.
And in this day and age, it's so easy. Not only you pull up somebody's email account, but you can search for keywords within the email and certain things. So it's not like you have to read each and every single piece of correspondence. But I would say that in terms of covering your assets and best practices, it's probably, wouldn't you say it's probably a good idea to have some kind of policy where you periodically pick a sample of employees and just go through their internet usage and things like that? But I guess the flip side might be is that people feel that those types of things are very intrusive. So you really have to approach it delicately, because like you said, making a big deal out of an employee who's watching March Madness, but other than that is really good at their job, it may be a battle that you don't want to start, because you could potentially lose the employee.
Well, and I think it comes down to a matter of resources. If bigger companies are going to have a dedicated IT department that may have the time and energy to devote to doing more monitoring of internet usage or emails, versus a small company that outsources its IT services to a contractor because it's not big enough to have its own IT person. So in a lot of cases, just having the policy and the threat of monitoring may be enough to prevent employees from misusing work resources. And as you pointed out, there are employees who will feel violated if they know that their employer is watching what they're doing, and they're not going to like it. And they may go find another place to work because they feel like it's an invasion of their privacy, even though technically it's not, but it may drive some folks away. So that's another consideration.
All right. Well, and again, that goes back to consistency, crafting a policy, having some systems of I guess, I don't know, good, it said good monitoring practices. And of course, it all comes back. We talk about this in just about every episode. Communication, properly communicating with your staff, making sure that you set the expectations. And again, if you're willing to tolerate the March Madness or the YouTube videos or the shopping or the fantasy football, I think it's safe to say, as long as an employee is still doing their job and not abusing those privileges, then no harm, no foul. But I think we've kind of touched on it a little bit where an employer could get into trouble is maybe they're looking to, we did an episode on constructive discharge. So all of a sudden they've decided that they want to try to terminate an employee because they don't like them for whatever reason. And instead of coming up with a specific reason, maybe they do something like, oh, you're shopping on company time. Yeah, I actually had a situation where an employer, when they terminated me, one of the reasons that they gave was that I was purchasing Garth Brooks tickets on company time and on a company computer. So,
so they were just not country music fans?
No, I think they just weren't a fan of me. So they were just trying to get rid of me. But that was one of the things where they were sort of piling on, looking for reasons to terminate me. That creates a problem in terms of if there was a potential lawsuit, and in that case there was. You're looking at the thing, and a judge, I think, would look at that and go, really? You're going to fire a guy for purchasing concert tickets online? Like nobody does any kind of shopping or anything like that while they're working. So, I mean, I think, again, it comes down to if you're going to enforce it, you're going to have to enforce it hard. Or if you're not going to enforce it, then you're going to lose those battles over the Garth Brooks tickets. Whereas if I was, again, looking at porn, I think that's a no-brainer. I don't think a judge is going to be like, well, most employees look at porn at work. I mean, porn producers, I imagine, look at porn at work because that's
and directors,
their work, yes, and directors, and maybe actors. But beyond that, I don't think of any case where maybe you're going to be, police officers. But then again, not a lot of people. And you know who you don't want? You don't want the sex police coming to your door at work.
No. The sex police will be monitoring your porn usage for sure.
But I mean, do you agree with that in terms of, trying to use that as a means to terminate an employee when it's just something that goes on? So I guess on some level, maybe you do at least have to address those issues like, oh, we know March Madness is coming up and people are going to be watching the games. Please. I think I've probably had emails like that over the years. Please be wary of the computer resources that you might bog down the network. We know you're doing it, but please think about it and just don't do it as much.
Well, it goes back to consistency that we always talk about. Be consistent in the way that you enforce the policy. So like you said, if your company wants to crack down on people using company resources for anything other than work, you better crack down on everybody who's doing it and not just a few people. Don't single out somebody for special treatment just because you're trying to get rid of them, because that could lead to a lawsuit, as you pointed out. But it's important to just also, you can use it for perhaps performance-related issues. If you have an employee whose job performance is suffering or who isn't as productive as other employees, one way to investigate that may be to look at their internet usage or email usage and find out how much time are they actually devoting to work. And if it turns out that employee is spending more time on non-work related activities, then that's a reason for having a counseling session with that employee and letting them know that, we're aware of how much time you're spending on non-work activities. Give them a chance to correct the behavior, give them a time period. If we need to see significant improvement within the next 30, 60, 90 days. And if we don't, this is the consequence. So it's a tool that can be used when you have the underperforming employee and you want to figure out what's going on.
Yeah, and I think and I think also it could be used as justification for, as the workplace, again, we talked about during the pandemic, many people started working at home and they became accustomed to working at home, so they want to work at home, and they'll try to make that case. The employer could make the case that they're not productive at home based on data from the device that they're supposed to be performing their work on at home and say, well, we can't monitor you properly, so therefore you need to start coming into the office. And, that may not be every day, but whatever. And I think too, it's speaking from, past experiences, I think employers just on occasion need to maybe send out a reminder email that says, oh, by the way, we do have the ability to monitor everything. And everyone, they'll probably be like, oh my God, who did something? They may be more vigilant.
Yeah, those emails are usually not very constructive. I think that's more of a, walk and talk and say, hey, if HR is walking by somebody's office and sees eBay up on their computer screen, just kind of, point out, hey, remember, we do monitor internet if we want to, and you need to get back to work.
And we'll close with this because it's about time to wrap up. But I would say a very effective use of your electronic resources at work would be, especially if you were an HR professional or business owner, would be to listen to this podcast, because it would be. It truly is work related. And although we do mention the word porn in it, there is absolutely nothing sexually inappropriate about any of our episodes at all. No.
In fact, we are actively discouraging the watching of porn during work hours.
Right. And if you you don't realize that, then you are a special kind of stupid.
Indeed.
Stupid is as stupid does, as my friend Forrest used to say.
That's
all right. Any takeaways that we missed here?
Make sure that you have a written policy regarding the kind of monitoring you're doing, and make sure you communicate that policy to your employees. Know your state law, know what your state law requires with regards to such policies, and be consistent in the enforcement of your policy.
And if you discover any kind of criminal activity or a potential threat to the workplace, just do the right thing. Report it.
You probably need to report it.
Yes, absolutely. Well, as always, thank you, resident expert / sister. So contact information.
As always, give me an email at kjj@wimlaw.com.
And of course, to our special listeners out in Russia, just stop. Stop doing what you're doing out there in Russia. Aside from listening to this podcast, which is productive.
Do you think that's really going to help?
You know what? It can't hurt.
Every little bit.
Every little bit.
That's beautiful.
All right. And Vladimir's monitoring all of our conversations.
Well, I mean, that's a place where monitoring is pretty prevalent. So if they're listening to us in Russia, perhaps they'll pick up some pointers.
Absolutely. All right. Well, once again, thank you very much for listening to the Cover Your Assets podcast, the premier, the top-rated podcast in Russia for United States labor and employment law. And thank you very much. We will see you next time. Please share. Please send us emails, anything for topics. We're definitely enjoying this, but we can always get better. And just let us know what you think we can do that would make this podcast something very useful for you. And, of course, useful for us. From your host, and, of course, my resident expert sister. We'll see you next time.